right, Doctor, just to start off, Dr. Panduleni of IPC has just rejected the position of the official opposition party in Parliament, but something he found there, he said that the position is illegal. What does the law say?
Thank you very much. I am not a legal person, but my understanding is that a constitution in a constitutional democracy ought to be interpreted broadly and purposive. In other words, not everything is written in the Constitution. This is the principle that Chief Justice Ismail Mohammed have established, who was the Chief Justice of Namibia from 1992 to 1999. Secondly, there are conventions and practices. Namibia follow the Westminster style of parliament. And one of its principles is the separation of power between the executive and the legislature. And therefore, it presupposes that the leader of the official opposition, as the president or the government in waiting, is supposed to be in parliament. So, on the basis of conventions, as well as on the basis of practices, we can rely on that even if it is not stated in the Namibian constitution.
So in his words, he said the leader of the office of the official opposition, attaching benefits and also just looking at demonstrating that it is administrative and ceremonial and symbolic rather than being lawful. Do you agree with that?
I don't agree. I think that is a personal view. And in our country, if there's a problem with interpretation of statutes, the courts are the authority to provide clarity. I don't agree on the basis of what I explained. Not everything is written in the Constitution. Some of the parliamentary procedures and processes that we see are in parliamentary procedures, are in conventions, are in practices. Therefore, we cannot argue that the leader of an opposition party in a constitutional democracy is symbolic and administrative in nature because it is the alternative government. If the argument is correct, that everything that we do must be found in the Constitution, why is the IPC talking about shadow ministers which are not in the Constitution? But I think you can find it in practices as well as in convention. So I don't agree with that argument.
And if IPC hold on its decision over this position, does it all have any implications, whether it's in parliamentary proceedings or administration-wise?
In my view, it has implications because of the following reasons. In the case of Namibia, the legislative authority vests in the National Assembly. In other words, Parliament is the authority in lawmaking. If an official opposition party or the majority party, as it is called, is the opposition, then the Parliament is the platform at which they articulate alternative policies so that the voters, when they have to vote, can look at these alternative policies and vote for that party. I think the absence is one of the implications that are there. And as I've argued in other commentaries, who say certain thing matters. This is even in a traditional setup. When the Hompa says something, it doesn't carry the same weight when it is said by a headman or a headwoman. When the leader of the official opposition speaks in parliament as an alternative government, as a president in waiting, what he or she says have more weight than when it is said by an ordinary member of that political party. But the main issue for me is, where will we as citizens, as voters, hear the alternative views, including keeping government accountable, if it is not through parliament where the leader is represented? So these are the implications for me, that perhaps we are underestimating the intelligence of the citizens, and this might have political implications.
Doctor, what guided the previous decision to have such an office and perks?
Like I explained, there are conventions and practices in the parliamentary system of Westminster parliaments. And I think it was guided by that. And as in public policy, a practice becomes a policy. Therefore, I don't think it is accurate to argue that there is no legal basis. I think interpreting the Constitution broadly and purposive, as well as conventions and practice, might have influenced past practices, and I don't see anything wrong with that.
Of course. And lastly, Doctor, just adding with your closing remarks as well, if IPC's position is anything to go by, can it be challenged in court of law, or what will be the remedy to establish the office legally?
I think the issue is just because I think Parliament is presented with an issue that we have never experienced. And therefore, they can approach the courts to provide interpretation of what the statutes say, what the conventions say, what practices have state. And on the basis of that, we can have clarity on the matter. So if there is no clarity on a legal matter, the courts are the best to interpret it. To give you a practical example, our Constitution does not say that you cannot apply corporal punishment. But when that matter was brought to the court to provide clarity, Judge Mohammed ruled that it is degrading on the dignity of a person. Therefore, corporal punishment, even if it is not mentioned in the Constitution, is illegal. So the same with this matter, because we are in an area of uncertainties, I think Parliament or any other matter who want clarity can approach the courts, and the court will provide clarity for all of us.